States. In 2003, when this town on the island was winding about the 29 employees, 29 grand, now it's 11,800. And it's tacked on another $2 billion because they just keep getting out prices to stop manholes, not to us.
Over a quarter of it is really well
and at least proposal to cap the maximum salary at the IRS is 95 grand. It's only to protect those people who are making over 150. I so support you in the library vote. Do good work. We got co-owners right now. I've got it. I stand chastised.
Actually, he's one of the library guys, Mr. Hart's.
Good for you.
I did a tabulation on Ramlet, and she's been on the commission for 10. She's been fighting exactly
Call this meeting to order. Take roll call. Commissioner Studley.
Present, and I apologize.
Commissioner Ward. Here. Commissioner Ham. Here. Commissioner Liu.
Here.
First item on the agenda is public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Yes, time for public comment?
Yes.
I'm not going to keep coming, but I would appreciate if you'd listen to me one more time on the subject of the complaint that was heard about the Library Commission. I explained during that hearing what they used to call the motor cauldron, which is how they describe public participation, namely bullshit. But it does not stop there. Library commissioners will tell you that you should get a life and all kinds of vile stuff. Not only will they laugh at you while you're talking, but the more reasonable you are, the harder they laugh. What's funny is that you have no access to the truth or decency whatsoever. But more importantly, the lies are incredible. They will claim that the sun does not rise in the east and water doesn't run downhill, and then they will laugh at you for thinking so. And when the level of corruption and irresponsibility is exposed by a controller's report or an outside audit or a newspaper expose, a glimmer of recognition will not pass their eyeballs. There are political and sociological studies which demonstrate that the accumulation of our power in our society takes place on the axis of psychological abuse, what I call psych assault. There's a quotation I've used many times from Hannah Arendt, and it goes, if everyone always lies to you, the consequence is not that you believe the lies, but rather that no one believes anything any longer. And the people that no longer can believe anything cannot make up its mind. It is deprived not only of its capacity to act, but its capacity to think and to judge. And with such a people that you can do what you please. What they will claim is that they're only alienating the alienated, and they're only disenfranchising the disenfranchised. But the truth is, you can do it to the entire society. Everyone thinks that the terrible part is that they are just thieves, and that they raise millions of dollars for their private nonprofit, and the public only gets pennies. That's not the terrible part. The terrible part is that hundreds of thousands of our citizens have to bear the burden of being alienated from our society, and the society suffers from the loss of that participation because truth and decency is limited to those who create the influence peddlers for influence. And that's what I mean when I say the lies cost more than money. Thank you.
Good afternoon, Commissioners. My name is Dr. Derek Kerr. After 20 years at Laguna Honda, I became a whistleblower, and then I lost my job. In 2009, Davis Shaw and Associates received a $49,000 contract with CBHS, Community Behavioral Health Services, to study behavioral care at Laguna Honda Hospital. The report by Davis Shaw was so biased and flawed that we just had to look at how this contract was awarded. We found that Davis Shaw's proposal showed a deep, almost an insider's understanding of what CBHS wanted. Public records showed that Davis Shaw resided at the same address as Deborah Sherwood, PhD, the Director of Research, Evaluation and Quality Management at CBHS. Also, we found that Shaw and Sherwood co-owned the property where the office of Davis, Shaw and Associates is located. This undisclosed domestic and business relationship between a contractor and a CBHS executive led us to file a whistleblower complaint. That was 2 years ago. We're still waiting for your determination. Meanwhile, we learned that Davis Shaw and Associates received another contract for $1.9 million to assess the quality of CBHS substance abuse services. We found that at CBHS, Deborah Sherwood was the project manager, had co-authored the RFP, was involved in setting up the review panel, and her deputy at CBHS was appointed to the review panel that looked at this contract. Davis Shaw and Associates won this contract over UCLA, a nationally recognized expert in substance abuse services. How objective will Davis Shaw be in evaluating the quality of CBHS services if his partner is the Director of Quality Management at CBHS? Thank you.
Good evening, Commissioners. Dr. Maria Rivero. I worked at Laguna Honda for 22 years before I was driven out of my job. The city charter states that no officer or employee of the city shall make or influence a decision of the city in which the officer or employee has a financial interest. 2 years ago, we reported to the Ethics Commission a potential conflict of interest between then Health Director Dr. Mitchell Katz and a contractor, Health Management Associates, or HMA. In 2005 and 2006, HMA received a $250,000 contract to assess the health department. Just 2 years later, Director Katz was on HMA's payroll as a paid consultant, receiving over $10,000 a year from HMA. In 2009, the health department approved a new contract with HMA for $65,000 that was later increased to $103,000. The health department provided the funding for this contract. Dr. Katz recommended, approved, and oversaw HMA's contract. At the same time, HMA paid Dr. Katz $10,000 to do consulting work for HMA. So the way it went was that HMA got $103,000 from the Department of Public Health in the city, and Dr. Katz, the Director of Health, got $30,000 from HMA. With this kind of arrangement, the city loses the ability to objectively evaluate the contract and the services provided by the contractor. No department head should be a paid consultant for a city contractor who provides services for their department. This is a basic conflict of interest. We hope that you will prevent this from happening again. Thank you very much.
Good afternoon, Commissioners. I'm Patrick Burnett-Shaw. Following your last meeting, in which you recommended to the mayor that he remove Joelle Gomez from the Library Commission, I went out into the hallway to congratulate Ms. Gomez as being the first person in city history who had been heard at ethics for a sunshine violation. I also wanted to congratulate her for having been the first person in San Francisco to be referred to the mayor for removal. She dropped her jacket, bending over, picking it up. She flipped it at me, trying to strike me with it. This commission needs to put on every agenda for your upcoming meetings the status report of the response from the mayor. Mr. Interim Mayor should not seek to become our elected mayor until he takes enforcement action on Ms. Gomez. And your duty is to hound him and to follow up until he does something. Thank you.
Good evening. I'm Rita O'Flynn. I'm here to speak with you about my experience with the Ethics Commission. I'm basically here to tell you that I'm in agreement with the findings of the grand jury because this commission has failed egregiously in the matter of O'Flynn versus the Mayor's Office of Housing. In 2005, the Mayor's Office of Housing included my programs in its lead hazard program. In 2008, I got to look at the records from my property. I noticed many documents, especially email, indicative of fraud, embezzlement, perjury, waste, and mismanagement on the part of the Mayor's Office of Housing. The copies of the complete files that I received from the Mayor's Office of Housing order did not contain the email that I had seen, and those that I knew existed based on the email strings I saw. According to Douglas Shoemaker, and I'm sure you all know who that is, the email were destroyed in compliance with the Mayor's Office of Housing's record-keeping policy. I knew this to be false and pursued my rights to these records via the Sunshine Ordinance. In 2010, the Sunshine Ordinance, this task force confirmed its earlier determination that MOH had destroyed email 2 years before its record policies permitted, and further determined that the Mayor's Office of Housing failed to restore the email of a Mayor's Office employee, Myrna Melgar, as ordered. The matter was referred to the Ethics Commission for further consideration. This referral to the Commission included a CD with hundreds of pages of evidence to support the finding of the Sunshine Ordinance Task Force. That the Mayor's Office of Housing violated its own record-keeping policy or failed to provide the email had been clearly established, and there was no need to waste the Commission's time or taxpayers' money to reinvestigate established facts or revise history. According to Richard Moe, this commission was to advise what, if any, action would be taken next. Additional investigation on the part of the commission could have been undertaken to determine exactly who destroyed the email, why Mr. Shoemaker misinformed me regarding the retention policy, and why the alleged restoration of Melgar's email didn't produce all the main email. But this was not done. Rather, after 14 months, the Commission issued a report in which it disputed all of the established findings of the Sunshine Ordinance Task Force. It did so despite overwhelming evidence to the contrary, and apparently with nothing more than an undocumented interview with a city employee who was not a party to the email, didn't destroy them, and wasn't even working for the Mayor's Office of Housing at the time. It's important for this Commission to know that I was and am more than happy to answer questions regarding this matter. However, as I clearly indicated to the Commission in numerous emails, I'm not comfortable engaging in any communication with the city that are not in writing or otherwise independently documented. Mr. LaCroix was well aware of this more than reasonable stipulation, however, chose to misrepresent that I was non-responsive to requests for information. This, along with the absurd findings in the final report for O'Flynn versus Mayor's Office of Housing, are very much in line with the grand jury's report indicating that dismissal of facts seems to be the modus operandi for this commission.
Thank you, Ms. O'Flynn. It's a 3-minute limit.
Good evening. I'm Alan Grossman. I've appeared before this commission any number of times over the last 4 or 5 years, so I predate some of the sitting commissioners. As you work your way through the agenda, there will be references to the role of the Sunshine Ordinance Task Force and to the role of the Ethics Commission in fulfilling the obligations of the task force. My comment now is related to the developed disrespect, I think, that's been fostered by the staff of the Ethics Commission and by the lawyers in the City Attorney's Office regarding the task force. And I need only quote Matt Dorsey, who is the Public Information Officer for Dennis Rivera. This is what he said, and was quoted in an article in the New York Times in March of this year. It saddens me that the task force has degenerated into a rogue, lawless jury that beats up on city departments and tries to get conscientious public employees fired. Because by doing so, it has surrendered the influence and leadership it should hold throughout the city government. The task force ought to be the conscience of the Sunshine Ordinance, but I doubt you find anyone who thinks they're actually accomplishing that today. Now, this is a public information officer for the task force lawyer, in effect defaming his client. Mr. St. Croix, on his part, in the same article, said that the task force often lacked due process, and his department had an obligation to review the cases. Having seen all the files in the 14 dismissed cases, and I'm the only one who has, I can assure you that the investigative process that Mr. St. Croix's staff pursued is nothing like the due process that is afforded to a complainant and a respondent when they appear before the task force. 3 hearings and a lot more time, if you can possibly imagine. In any case, that's important. I also want to mention, if you haven't seen it, that the task force has sent over its proposed changes to the draft regulations on sunshine enforcement matters. And I trust that it will be taken up in due course, because it's very important at this time. Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government, and I do intend to comment on the agenda item relating to the civil grand jury report, but I'm going to add something that was not covered in the report, which I think is germane. I have here in my hand a letter from this body, signed by Mr. St. Croix, dismissing a sunshine complaint I filed directly with this body. So it doesn't seem whether or not a sunshine complaint is filed directly with you or goes through the Sunshine Ordinance Task Force and is referred to you, they are all dismissed by the staff. Now, I don't know how you feel about the legal system or the judicatory system, whatever you want to call this, but the bottom line is most Americans, and I think most San Franciscos, feel that if a person has their day in court and they can't make their case and they lose, well, they had their day in court. But what we have here is a body that, for whatever reason, has decided to completely abdicate its responsibility by delegating it to the executive director and taking whatever he gives you as gospel. Not one time have you taken a case and had the person come in and give you the same evidence and arguments that they presented to the Sunshine Ordinance Task Force to show you why they felt it was appropriate to find a city body in violation. So basically what you have done is something we used to call in the military, delegation is not abdication. The simple fact that you have delegated your full responsibility for sunshine to Mr. St. Croix and has simply rubber stamped every single thing that he has put forward as a recommendation doesn't say very much for you, because you have absolutely no basis, not having heard a case, to determine whether or not his recommendations are valid or not. And I think how you prove that is our case last month, where you actually, for the first time, heard a case and found out that there was a basis for an action. And I think basically you have denied due process to every single person who has either filed a complaint through SOTF and had it referred to you, or filed cases. And I know I'm not going to get an answer from Mr. St. Croix. I'd be interested to know during the same time frame covered by the grand jury, how many sunshine complaints came to this body directly and were dismissed out of hand.
The next item on the agenda is consideration of possible response to the 2010 and 11 civil grand jury report. Mr. St. Croix would like to reintroduce this agenda item.
Our response to the civil grand jury report is due next week. This is a redrafting of the original, having taken into consideration suggestions and by the commission, and also consideration of other feedback and public comment.
My thought on this agenda item was to first solicit public comment and then have the commissioners discuss. If that would be acceptable to the other commissioners, unless there's any objection. So we'll first take public comment on the civil grand jury report.
Yes, thank you. I'd like to call your attention to finding number 3, where the civil grand jury recommends that you begin your own investigation 14 days after a case is referred to law enforcement. We agree because our complaints were stalled for 9 months before the district attorney decided not to press criminal charges. Your response to the civil grand jury is that number 1, you don't want to duplicate investigations, and number 2, you want the leeway to prioritize your work. But criminal investigations are different than ethics investigations. There may be some overlap, but you are not duplicating law enforcement investigations. Also, in our cases, the district attorney refused to disclose to you what their findings were. Information that you never get cannot be duplicated. There's no risk of duplication. Whether you wait 9 months or whether you investigate after 14 days, you still have to start from scratch. So why wait 9 months? We all understand the need to prioritize when you're short-staffed. But we also understand how prioritizing can be used to bury politically awkward complaints. How do we separate prioritizing from stonewalling? I have a suggestion. Please consider showing on your agenda the date when a complaint is received. That way, commissioners and the public can tell if a case is being addressed in a timely fashion. Thank you.
Good afternoon, Commissioner. Stop the court to wait the public library. Don't give money to Friends of Foundation. Don't accept money from Friends of Foundation. I always present my public comments that way, and I think I forgot that the first time around. I'm a little incredulous that there are not copies available for the public of the amended response. I might have some specific comments if copies were available, but since they're not, I think I have 2 general comments that will have to suffice. First of all, have you ever been to a football game? I haven't been to a football game in years. I certainly haven't been to one in person, probably in 40 years. But there's the first rule of football, before all the others. That is that if you have 4 losing seasons in a row, you fire the coach. Now, this is the situation with this ethics commission. I'm sure Mr. St. Croix thinks that he's doing what somebody wants him to do. He's certainly doing what he's been allowed to do all this time. But you now need to send a message that you're going to have winning seasons in the future, you're going to do something different, and that's what firing the coach does. It doesn't mean that he doesn't get his gold watch and a nice dinner. You know, it's not about Mr. St. Croix. It's about setting a new direction for the future. Number two, the first thing they tell you when you're a kid is that it's not about punishment, it's about deterrence. If you have a hard rule and consequences to it, it's supposed to prevent the illegalities or the transgressions or whatever it is in the first place. If this Ethics Commission had a record of swift and efficient enforcement, there would be a rippling effect throughout City Hall of compliance with ethics and compliance with good government principles. The fact that there's been an absolute blank wall, a wall of denial that this ethics confronts people with, that every time some member of the public tries to approach it, has sent the opposite, which is that there is no good government in City Hall and there's no ethics in City Hall. Thank you very much.
I also believe there are more copies of the proposed amended response made available. I apologize, it appears that they may have run out by now. Go ahead, sir.
Thank you. My name is Hal Smith, citizen of San Francisco. I'd first of all like to commend you for the tone of the civil grand jury response this month in comparison to last month. It's much better. I may not agree with everything you have said in there, but I appreciate the tone. It's much more reasonable and much more reasoned. I would ask you to think about finding number 7 much more carefully. I find that putting this information, putting what you're doing on television is very important. As stated in your response, whoever wrote the response thinks it's a luxury. I don't think putting the key information that you folks have in front of you is a luxury to the citizens of San Francisco. I think it's very important. I think you think it's very important, or you wouldn't sit here and listen for 3 hours about what people say all the time. And based on the executive director's report this month, you have a budget of over $2.5 million. Based on what we found out in the information last month, putting this on television would cost less than $10,000. That's less than 0.4% of your overall budget. Another argument was there's another group that has their presentation on at this time. That's fine. It doesn't need to be live. The people of San Francisco just want to know what's going on. And they want to know what's going on in this body. So I don't think it's a luxury by any means. What you decide is a priority will become a priority. If you don't think this is a priority now, it won't be a priority. You need to change your priorities so that the people of San Francisco can see what's happening in this organization. Right at the bottom of your agenda, one of the things it says is, we do this in the full view of the public. It can't be in the full view of the public if it's not on television. I ask that you reconsider, look at that finding, and please find less than 0.4% of your budget and put this on television. Thank you.
Good evening, Commissioners. My name is Brian Clement, and I served on the prior civil grand jury. And I'd just like to comment on 2 of the responses that came forward. First has to do with finding number 1, the recommendation that a fee structure be established. We probably weren't as clear as we could have been in that you can't have multiple fees for a particular violation, one for someone that just did it once and one for someone who's been a repeat violator. The idea is to get the establishment of the fines out of a backroom deal, which is what it appears to be now, and bring it more into the public debate, where if someone has a problem with the fine, they come forward to the commission and state their case in front of the full commission, rather than it being negotiated specifically by members of the staff. The other item has to do with finding number 5, with the delegation of, or the dismissal of items from the agenda, requiring more than one commissioner to dismiss those items. As we stated in the report, because of the fact that commissioners can only contact one other commissioner without being in violation of sunshine, the requirement that two of the commissioners have a question about something and having it brought to the agenda makes a relatively high bar for things to be brought forward. And it appears, based on your data and the numbers, that a lot of things just get covered and closed by the executive director. And I would encourage you to recommend looking at changing your own regulations to allow just one commissioner. If one commissioner has a question about something, that should be enough to bring the discussion forward to the full commission. Thank you.
I appreciate if you let me know when I have 1 minute left. Commissioners Ray Hartz, Director, San Francisco Open Government. My comments are going to be strictly on finding number 2 regarding to the Sunshine Ordinance Task Force recommendations to this body. There's an old expression, give him enough rope, it'll hang himself. And you got enough rope. You basically had 5 years worth of recommendations that were sent over to you, and every single one of them was dismissed without a hearing. So what you're saying is, of the dozens of cases that the Sunshine Ordinance Task Force hears each year, they send you on average 3 cases, and you couldn't be bothered to hear them. Those 3 cases were citizens trying to either get public comment or access to public records, things that are guaranteed by law. You didn't want to help them. Why? Why is it that nobody on this body seems to think that those flags hanging in the front of this room and the oath you took to support and defend the Constitution of the United States are worth taking the time or trouble to have a hearing for an individual who feels those rights were denied, especially when they have another government commission from this city, appointed by many of the same people who appoint you, who've agreed with them and said they were denied those opportunities. No, just too much trouble. Instead, their rights were completely abrogated. They were given over to your staff, and you have completely abandoned your oath of office to support and defend the Constitution. Some of these issues were free speech issues. People were denied the opportunity to get up in a public forum and say what they had to say. And you didn't seem to feel that that was important enough to even look at it. I think personally it's an insult to the millions of men and women who have served in our armed forces, who serve now, who do give up their lives and suffer so much to protect the rights that citizens have and are supposed to have with those flags in the front of the room. I think you should be ashamed. I think it should be something that you should not sit here and say, well, you know, we disagree. And, you know, you can give it lip service as much as you want to say, we appreciate the grand jury's efforts, but then completely dismiss pretty much everything they say. That is a slap in the face, not only to them, but to the justice system, and again, to those flags. I think it's a matter of shame. And if you can't do your job, you should resign.
Dr. Derek Kerr and I filed whistleblower complaints about our employer of 22 years, Laguna Honda Hospital, and the Department of Public Health. Soon after that, we both lost our jobs. Almost 2 years ago, we filed these 3 complaints and a whistleblower retaliation complaint about a year ago. These cases are all open and under investigation by the Ethics Commission. While the Ethics Commission did actually interview us on one occasion, the rest of the time we were kept in the dark. Furthermore, the Ethics Commission stood by while we were harassed and driven out of our long-term employment with the city. Whistleblowers, especially those that are insiders in city departments like we were, have valuable knowledge that can help investigators understand the complexities of a complaint so that the investigations actually result in complete and balanced conclusions. Whistleblowers really have to be integral partners in ethics investigations. Otherwise, the investigations are a job half done and don't really serve the public. I must say that I wholeheartedly agree with the findings of the civil grand jury and encourage the Ethics Commission to adopt the civil grand jury recommendations to increase communication with whistleblowers and increase the transparency of the process. Thank you very much.
Good evening again, Commissioner Patrick Manetshaw. Of the grand jury's 8 recommendations, this commission agreed with only 1, disagreed with 2, and was neutral or provided no position on the other 5. On finding number 2, the commission's response says it, quotes, stands by its findings, end quote, on the 18 sunshine referrals that were simply dismissed here at Ethics. Those 18 referrals were sent for enforcement of the adjudication that SOTF had already gone through. But Ethics re-adjudicated the cases rather than focusing on enforcement. The grand jury noted SOTF had found violations and referred the case to Ethics for enforcement. The grand jury noted Ethics has not taken any action on the violations. You dismissed 8 of the 18 because, quote, facts did not support willful failure, end quote. The other 10 cases you dismissed because, quote, facts did not support a violation. You're not supposed to be looking at facts. That had already been done, and that's the job of SOTF. Your job is enforcement. The grand jury's report went on to say that none of those 18 cases were heard at an open hearing. You didn't mention that in your response at all to the grand jury, which is sad. What you should do is reschedule each of those 18 hearings in an open forum and invite the original complainants to come before you and focus this time simply on enforcement. On finding and recommendation number 3, when you presented your draft response to the grand jury a couple of weeks back, I had to sadly inform you, you are not a law enforcement agency. You're a commission, just like any other board and commission in the city. You're not the CHP, you're not the police, you're not the sheriff, and so your response to the grand jury in its revised format needs to strike the word other law enforcement agencies from your reply to the grand jury. You have to wake up and smell the coffee. You are not a law enforcement agency.
Hello, Rita O'Flynn again. I wanted to just take a moment to speak to you about your response to the grand jury report. I'd like you to look at this as an opportunity to fix what's wrong. It's clear and it's obvious from the people who are speaking here that there is something terribly wrong. The public cannot vote you out of this position. You can't, there's no avenue of appeal for the decisions that are made or not made. You have an opportunity that not a lot of commissions and not a lot of people in public service get. And I want to encourage you to take this opportunity seriously. Fix what's wrong. Do your jobs the way it needs to be done. Thank you.
Good evening, Commissioners. My name is Hope Johnson. I'm speaking as a citizen, but also I'm the chair of the Sunshine Ordinance Task Force. I wanted to talk to you a little bit about finding number 2. As I said at your last hearing, the focus in the civil grand jury report was about open public hearings, not just about the idea of dismissing these referrals. So I would encourage you to consider having some open meetings about this so that it can be public, that the commissioners are involved and have an understanding of exactly what is going on and that the public can have a say as well. In addition, I wanted to address previously, Mr. Alan Grossman had discussed that I sent a letter to the commissioners requesting a joint meeting with our Compliance and Amendments Committee, and I want to encourage you to do that. Mr. St. Croix was before us in one of our cases recently on several occasions, and he referenced to the adversarial relationship that's developed between the Sunshine Ordinance Task Force and members of the Ethics Commission staff. And that joint meeting would probably do a lot to alleviate that, and also in the future, we could be hopefully on the same page. Thank you.
I think it's important, I don't have to reintroduce myself again. I think it's important that you get a sense of why some of us who are supporters of the task force are so chagrined by this history, long history of dismissals that seem totally inappropriate. There were 3 dismissals that were issued in November 2008, and I will read briefly from each. The task force erroneously concluded that the Sunshine Ordinance requires disclosure of calendars and so forth. City attorney has determined that disclosure is only required in certain cases. Important language. As legal counsel to the city and county of San Francisco, the city attorney is a higher authority than the task force when it comes to determining the legal duties of city departments. The Ethics Commission recognizes the city attorney's conclusion in this matter. That's one of them. Same day, same point. City attorneys made an opposing interpretation and so forth and so on. In facing such a conflict of opinion, the Ethics Commission is on record as holding that the charter always preempts the Sunshine Ordinance. Always preempts. And then goes on to say, as a lead attorney in the city and county, having been elected by the people of San Francisco to that position, the city attorney is higher authority than the task force, whose members are appointed as you are. It goes on, and in the next case, the same thing. The point I'm trying to make is, I submitted a records request for the legal authority, the opinions that Mr. St. Croix relied on in making those statements. His response was, and I quote, "There are no records responsive to categories 4, 5, and 6 of my request. The commission is on record as holding." I asked for the record. It doesn't exist. Thank you.
Good evening, City Watchdogs. Thomas Picarillo. First, let me say it's very nice to see a room full of concerned citizens interested in ethics in city government. It's great, love it. The issue of television, as you all know, this proceeding tonight is being televised, and it will be streamed online for the citizens who are unable to attend tonight, but perhaps maybe listening to your recording. It's my understanding that in all future Ethics Commission proceedings, they will be televised and they'll be streamed online. It's not a luxury that you can afford not to have these proceedings televised. Let me go back to the grand jury report. First, let me say that, it's troubling to me that only 2 of the 5 of you actually took the time to speak to the grand jury. That's most telling to me about your interest in grand jury proceedings and the processes of the Ethics Commission. Shame on the 3 of you who refused to talk to the grand jury. Regarding the turf war between you and the Sunshine Ordinance Task Force, it does no citizen any good who is seeking public records or wanting to testify in public meetings for you and the task force to have this turf war where there is no enforcement of violations of the Sunshine Ordinance. Sunshine Ordinance recommended a joint conference between you and the task force to rectify the problems that you're having regarding enforcing sunshine violations. I strongly urge you to heed that advice. And finally, let me say this. The grand juries basically concluded that you have the tail wagging the dog, in the sense that you delegated all your responsibility to Mr. St. Croix. That is the fault of the commissioners and not Mr. St. Croix. Thank you.
Commissioners, comments on the proposed revised response to the civil grand jury report. Commissioner Studley?
Sure. I do appreciate the revisions, and I think it is an improvement, and I appreciate the comments of the public and the specificity of addressing the particular findings. I do have a couple of thoughts. Finding number 2, we did have a thoughtful joint meeting with the Sunshine Ordinance Task Force, I believe about 2 years ago now. And I also believe that it was at the invitation of the Ethics Commission that we had that conversation. Since then, we have developed a number of proposals to help refine some of those areas of difference in order to accomplish what we are both trying to do, which is carry out the requirements of the law in San Francisco. I appreciate that we just received their response, and will be, I have a hearing, and we've gotten it, and we will be reviewing it very soon. And I, for one, would welcome the opportunity to meet with them again now that we've had that exchange of policies. As for the draft report before us, it seems to me that there, while nobody wants to word edit a document of this length at this hour with this many people wanting to speak to us on the other items on the agenda, I would rather that we replace the first paragraph, the first sentence of the second paragraph, to simply say that something like each referral is taken seriously and reviewed on its merits under the Ethics Commission's legal authority. And then for my part, I would cut to starting in May 2010 and talk about the reformulations that we have taken some trouble to develop in hopes of clarifying the legal situation. I think since the draft, we actually received the response from them, so we might want to reflect it there. Mr. Chair, would you rather do this by finding, or would you like me to go through it?
Perhaps you can do it by finding, so that we can address any comments as they come per finding. Any other comments with respect to finding number 1 or 2 in any response to Commissioner Studley's proposed revisions? Commissioner Lee?
I agree with Commissioner Studley's proposed change to the draft. I was also wondering if in the second paragraph, the last sentence on finding number 2, where the last sentence begins, the Ethics Commissioners will review and consider the comments from the SOTF, if we could consider inserting just a phrase, comma, including comments regarding the review and hearing process, comma, because that seems to be a primary concern, and I also would welcome the opportunity to meet with the Sunshine Task Force.
Any other comments with respect to Commissioner Weir?
So since this is a draft document, I'd like to put on the record what my point of view is with regard to certain of these responses. So, in finding number 1, I would encourage us to change the current rule that we have, that it takes 2 commissioners to agendize a item in connection with a dismissal. I think that if one of us feels like it ought to be taken up at a meeting, then that should be enough for it to be taken up at a meeting. So
I actually agree with that, but I think that's finding 5. But I think we should discuss that issue when we get to that finding. But frankly, I agree with you, Commissioner Warren. Any other comments with respect to findings 1 and 2?
Well, I do also think that a respondent should be able to request a public hearing if they disagree with a fine, but more to the point that someone in the public has just made, these negotiated agreements, if someone can't pay the fine that has been levied, then I feel like they should come before the commission and we should hear their reason for not being able to pay the actual fine that's being levied.
Any response to Commissioner Ward or Commissioner Studley or Commissioner Liu on findings 1 and 2? Commissioner Hammond?
I just have a couple of general comments that apply particularly to finding 2 and perhaps even finding 3 when we get to it. Someone who the public used the term swift and efficient enforcement. And I like the sound of that, and I think that is something that we as a commission should really push for. One of the things, since I'm still a fairly new commissioner, one of the things that has really surprised me is that we have cases that have been pending for months, if not years, and frankly, I still don't really understand that. I understand that there are some jurisdictional issues, particularly where the city attorney's office may be reviewing some of these cases, but somehow we need to figure out a process where people who bring a complaint to us feel that their complaints are addressed as quickly and, I might add, as publicly as possible. Perception is everything, and particularly in the area of politics and government, frankly, perception is reality. So the fact that so much of the work that the Ethics Commission is addressing is going on in a not public forum, I think is problematic. And while I may or may not agree with everyone that has commented on this, I do think that we need to find a process where more of these complaints are quickly brought before the commission, perhaps even before an investigation begins by our staff. So these are procedural issues, and I don't know if that language should go into our response to the civil grand jury. But I think that these are, really fundamental issues that we need to grapple with as commissioners. Because right now I think that there is a perception that too much goes on without a chance to be heard by interested members of the public. On the other hand, I would say to some of these comments that every city department is run by its executive directors. It is not. They're not run by the commissioners. the commissioners set policy, and I think while our role is slightly different from that because it's about enforcing these election and ethics ordinances, nonetheless, the executive director still maintains the bulk of the responsibility for how these procedures are enacted and decided. So those are kind of general comments that I just wanted to add, and I don't know if any of that language can be included in responses to 1 and 2, findings 1 and 2.
I think, Commissioner Han, I agree with your sentiment, certainly, and think that we should have the staff endeavor to find ways to make the process as efficient as possible, and agree that the public deserves a resolution as quickly as feasible. With respect to Commissioner Ward's comments, I also agree that for any person who receives a fine and who has an objection based on the ability to pay, I think that is something that we should hear and agree that it could be brought to us. I'm also in agreement with Commissioner Studley's revisions and Commissioner Liu's revisions to findings 1 and 2. My comments begin with finding 3. And I think this dovetails nicely with what Commissioner Han said. Unless there is a legal reason why we must wait for the city attorney or district attorney to assert jurisdiction, I think that we should endeavor to begin investigations after the 14-day window closes. I understand that there are limitations on what the staff can do, that we have substantial resource limitations that we are dealing with, but I am worried that the part of the delay, maybe a large part of the delay, is caused by our policy of waiting for the city attorney or the district attorney to assert jurisdiction. I don't know if Mr. St. Croix, if you have any, what the background policy basis is for that wait and whether that's something we have discretion.
I don't know that we have, I assume we have the ability to amend that. Right.
Yeah, the commission could, and yeah, in a situation where the circumstances merit, the commission could begin investigating while the district attorney and city attorney are reviewing.
I mean, I suppose it's possible that as a practical matter, an investigation would be stalled because it's possible that respondents would not want to participate if there was a district attorney or city attorney investigation. But if there's nothing preventing us from doing so, it seems as if we could at least start the process if we have willing participants. And so that would require a change in the regulations. Is that your understanding?
I don't think so. No, okay. It's just a purely policy problem.
So perhaps we can do findings 3, 4, and 5 as one in one chunk, if that's acceptable to commissioners. With respect to 5, I agree with Commissioner Ward that amending it as Mr. Clement suggested to one commissioner to have one calendar would be productive and is a good recommendation. Any other comments on 3, 4, or 5 from the commissioners? Commissioner Sutton?
On number 4, I didn't understand the second sentence of paragraph 2, the acknowledged conflict of interest. Appointed by members of the elected body of government. I'm not appointed to this non-paying position by a member of the elected body of government that provides our budget. And I think that's just not technically accurate for most of us. So I think that's just a factual correction. And I would change the word in the last line from "we would welcome the new choice of commissioner selection process," because I think that sounds inconsistent with what we've said before, which is the voters decide what method to use and how best to provide the protections and independence that they're looking for. And welcome sounds to me as though we hope they will. I would just change it to something as simple as accept. Number 5, I think, is much more substantive, and I also think that we would do well to consider changes to our practice here. My suggestion at the last meeting, when we were thinking about this, was that we might consider actually reversing our presumption and getting the same reports that we get in detail from the staff about what they have found and their recommendation, but that the presumption operate to say that it will be calendared for consideration unless we affirmatively vote that we are satisfied with the recommendation and all of the comprehensiveness of the investigation, and that we affirmatively vote that we do not need to hear it because we are satisfied with that. And it would be a different approach. If the other commissioners did not prefer that option, I would be satisfied, happy to move in the direction you, Commissioner Ward, have spoken about. But I think to Commissioner Ham's point about perception, I want to make it very clear that we are making these decisions. And I think one way to do that would be to say that they will be calendared. As I know I read every single one that comes to me. I have every reason to think that my fellow commissioners do. But if that is not absolutely clear to the public, this is one place where we can, in a very simple way, show them that while we stand on the work of the staff, that we are also setting the standard here and that we are making that change.
Any response to Commissioner Sudley or further comments with respect to findings 3 through 5? Commissioner Han?
On finding 4, on the suggestion, on finding 4 on the suggestion that there are additional 4 commissioners appointed by non-governmental entities. I at least would like to be on the record for being in opposition to that. I think the intent of the voters is to have commissioners who are at least appointed by people who were elected by the citizens of San Francisco. So while there may be some inherent conflict of interest, I don't see any way to avoid that. And I don't know what non-governmental entities would be recommended as organizations that would make appointments. I think there, the possibility of conflict of interest would be even greater. So I find that particular recommendation to be a little off-key from the civil grand jury. And I think that if we could find, I don't know if other commissioners agree with me, perhaps there could be additional commissioners. I mean, this is, compared to some other commissions, relatively a small commission. But I don't know how the other commissioners feel about the appointment of by non-governmental entities.
I for one, I definitely see where you're coming from. I'm comfortable with the language mostly because we have no say in how many other commissioners are appointed and who else is appointed and who appoints them, and it's a voter decision. So I personally think it is prudent to leave the commission recommendation as neutral, given that our recommendation really can have no effect on what ultimately is decided by the voters. But I agree with your reasoning, concern. I don't know if others have views on Commissioner Hand's suggestion with respect to the appointment by non-governmental entities. Any other comments with respect to findings 3 through 5?
So for finding number 5, if we were to reverse the presumption on how these matters are calendared, would we have to change a regulation to do that?
You would have to change your regulation, which you can't do at this meeting. I'd also recommend that you not come to a conclusion today about exactly how you might do that, whether it's to go to one person or multiple voters.
And so we would have to, it would be a change of regulation either way to either make it one commissioner or make it switch the presumption.
Right.
Okay. So maybe the prudent thing to do there would be to suggest that we are going to revisit this and establish a process, amend the process in some way. Is that acceptable to the commissioners? Yes. With respect to findings 6 and 7, any comments from the commissioners?
Could I just ask, a small editing change? And I agree with the last suggestion you made. Second paragraph, last sentence, I would make the simple statement, commissioners are notified in advance about which cases will be on the agenda. Eliminating the words up through that, the word not, and the sentence is not true. I think we should, the tone is more appropriate if it's simply stated.
Findings 6 and 7, comments from the commissioners?
So I want to go on record as being fully in favor of these meetings being televised. And I would encourage us to do what we can to find the resources within our budget to have them televised. Now, I know that's easier said than done, but I'm in favor of the meetings being televised and doing what we can to see that that's done.
I too would like to go on record. While there is a budgetary consideration, I think it's been pointed out that it need not be overly expensive. And really, these days, I mean, the issue of streaming video as well as, televising on the governmental station, I think is something that we should be doing. And I think also we could find a way to make better use of Facebook to put information out there about where we are, what we're doing, and what issues are on board. I think is important in this day and age of social media.
I would be in favor of getting a cost estimate for doing this because I am sensitive to the trade-offs with investigative and other staff. The last time we asked this question, it was admittedly a few years ago, the cost estimates were significant enough that it would have made a meaningful difference about trade-off in our ability to staff the work that we are already hopeful can be swift and efficient, and we didn't want to further constrain that. But I would very much welcome another look at that question, and would appreciate having an estimate for well, it would involve, it could well be that new technology allows us to do it in ways that are more economical, and that the cost benefit of people being able to see us in action would be, would be a good decision.
No, I agree. I think that we should definitely consider what it would cost to televise hearings and see if it's feasible to make room in the budget for it. So I would be in favor of figuring out how we can identify the cost and feasibility of that option.
And so I would propose that the response reflect the conversation that we just had.
I agree with that sentiment. So is there a motion to approve the response as amended by the commissioners to be sent to the, in response to the civil grand jury report?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Any opposed?
Comply with the ordinance. Now, I'm not suggesting you do not have a closed session. on this matter. But I do think it's important for someone in my position would be to know the criteria or elements that you're going to be using to determine the level of performance of the executive director. And I'm not quite sure how you would convey that or make it known, but there must be some sort of a system or procedure or sheet that outlines, you know, A, B, C, D, E, either terrible, good, wonderful, you name it. So that's the aspect that I'd be interested in hearing about. And as far as the disclosure of the information coming out, I think that given the amount of feedback you've gotten regarding the importance of this position and the fact that there's been some serious question about its effectiveness when, particularly in the case of the open government cases, that it would be worthwhile if the public knew how you were looking at that when evaluating the performance. Thank you.
Could I ask a question? Do you think that the performance reviews of all city employees ought to be made public?
You know, my hearing is bad.
Do you think that the performance reviews of all city employees should be made public?
Yeah, I do. I really do. I think there are privacy issues that could enter into it. You know, medical reasons perhaps affecting performance that might be suitably not made public in the interest of privacy, but I don't see any reason why it has to be completely confidential or secret. I'm not fully conversant with the law on that subject, at least the ordinance or the Public Records Act, but you know, my position, as you probably all know, is to make as much public as possible, you know, because without it, you can't have good government. Thank you.
David Middlepel, speaking also on item 5B and a general comment regarding the closed session. I just wanted to speak first in support of Director St. Croix and the work that he's doing and the work of supervising the staff, particularly in light of some of the comments I heard at the end of the last discussion item suggesting that there was a particular bias or motivation in that particular item. I don't believe that there was, and I believe that Director St. Croix brings a wealth of experience and good judgment and the ability to manage under difficult circumstances. And I just wanted to share that with you as you consider this evaluation. Also, with regard to the closed session, I will be taking all of my stuff with me. There appears to be an individual video recording the meeting. I would just hope that the commission would take care to ensure that everyone exits the room and brings all of their stuff. I'm not sure that we have not been in this situation before, that we take appropriate care that there are no recording devices in the room. I respect very much the confidentiality of the closed session and want to be sure that we're taking proper precautions. Thank you.
Thank you.
Is there a motion to move into closed session?
So moved.
Is there a second?
Second.
All in favor? Aye. Any opposed? So at this time, we'll be moving into closed session. All recording devices should be shut off and removed. The next item on the agenda is the minutes of the commission's regular meeting on July 11th.
We have to do the motions.
I'm sorry.
Session motions. You have to do redo the motion not to disclose.
Is there a motion not to disclose the deliberations of the closed session?
So moved.
Is there a second? All in favor? Public comment? No public comment? All in favor? Aye. All opposed? The next item on the agenda is minutes of the Commission's regular meeting of July 11, 2011. Any comments from the Commissioners? Any public comment?
Yeah, I received some public comment from David Kilco. Most of the comments are grammatical corrections and typos, so we will incorporate those.
Okay. Mr. Kilco, is there something else you wanted to say?
That's fine. I assume that there was no announcement out of closed session. I understand the motion not to disclose, but there was no announcement.
Of what?
Of anything. There was no announcement to me.
No.
Okay.
No. Correct.
Okay.
Is there a motion to approve the minutes of the July 11, 2011 meeting?
Did you make the motion?
I think we have it already.
Don't we take into consideration the...
Oh, yes. Taking into consideration the changes proposed by Mr. Pilpel, grammatical changes.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Any opposed? The next item on the agenda is the Executive Director's Report. Mr. St. Croix.
Just one quick highlight, the campaign consultant reform package was adopted unanimously by the Board of Supervisors and will appear on the November ballot. The Ballot Simplification Committee has met and prepared an analysis, which what their initial one was, I thought, quite fair and balanced. Mr. Larry Bush filed an appeal against it and had some language added that I don't think is a completely fair characterization, but it's part of the document now. So as we know, commissioners and staff can make comments to a factual nature on what's in there and what it does, but we're not allowed to publicly support or oppose ballot measures, including one of our own. So just a reminder. That's it.
Okay. Public comment?
David Pilpel. So first, as to the campaign consultant ordinance, does the staff have or will there be a summary of what the measure does that one can use to use in connection with the election?
There's a memo to the Board of Supervisors to that effect.
And that's kind of the best product?
I would say.
Okay. And is that on the website, or can it be put there more prominently? Not as an advocacy document, but for information? So that if someone says, well, what is this?
It's a public document.
Okay. I guess I'm suggesting if there's a way to highlight it between now and November, so that if someone asks, for example, what does this thing do, I can say, you can go to the website, there's a memo that pretty well describes it. Suggestion? Okay.
That's a good idea.
On the rest of the ED's report, I've made a couple of suggestions to staff. In the meantime, I will continue to repeat my request that all of the bad people be listed and that we find a way to get them off the bad list. I also think it would be useful to have a section on the status of laws and regulations. So for example, the CFRO amendments that you adopted last month in light of the Arizona case, I presume were sent over to the board and are sitting there. There's nothing in the ED's report that indicates that in the status. So I think just having a little placeholder section on that and regulations that may have been adopted that go into effect a certain date, just a little item for that would be helpful. Otherwise, on the non-filers on SEIs, I've asked the staff for that list of names. Again, in the future, I just think it's good to name names. If people know that doing a bad thing gets them on a more public document, they may have a more compelling reason to comply and not be in the public document. Thank you very much.
Actually, one quick question.
Yes.
Jack, you said that there are sufficient funds in the election campaign fund. Is that affected at all by the number of candidates, especially in the relatively more expensive mayoral race, or is there so much cushion for the $8 per person that that wouldn't?
There's sufficient funds so that everyone maxes out at the primary cap, which would be $900,000 each. There's enough money for that for all of the candidates if they max out, and there's more beyond that. The 59 days out before the election, I have to look at the balance and sort of publish what the actual cap would be. Even if caps are raised, you can't spend more than is in there. So we'll appropriate, and we'll average out what's left among the number of candidates, and that'll be the figure that we estimate is the max any campaign can get. But no one's ever actually hit that target. You look confused.
Mr. Belleville?
Yeah, I'm sorry. I think there was also a typo in the director's report. The second paragraph under the November 11 election item 2, the last date to submit an application. Is that not August 29th, the same date in the last sentence there?
Mr. Speaker?
Yeah.
Yeah. There's a typo.
Okay. Sorry. Thanks.
The next item on the agenda is items for future meetings. Are there any items that the commissioners wish to propose for a future agenda? Seeing none, public comment. Or do we take public comment on items for future agendas? Hearing none, public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
David Popel again. I'm sorry I was not here for your discussion on items 3 and 4. I only caught the last part of the discussion on Progress for All. I just wanted to point out to the Commission that the FPPC has a definition of candidate and elected officer, or elective officer, and regulations and guidelines to that effect. And I'm not sure if you were fully briefed on that. You may want to be specifically aware of that language and be open to reconsidering or rescinding your vote tonight.
It was raised, we discussed it extensively.
Okay, well, I looked at that language a little bit, and I'm not sure, based on that, if the definition of candidate was met or not met, so I just wanted to express that concern. Thanks. Thanks.
Is there a motion to adjourn the meeting?
So moved.
Is there a second?
Reluctantly.